if people try to bring, family members, there's detentions that occur at borders, including of people with green cards. A lot of people aren't aware of that. That people that even have legal documents can be detained until they're a U.S. citizen. They can really be detained, for long, long periods without often much access or without the government having to advise them that they have certain rights. And I've seen cases, in fact, where the government outright told people that if they got a lawyer, this is going to be, horrible. And so many people feel compelled to sign things which prejudice them greatly in those situations. What's strange, though, is that when people are merely present, so the crossing, as Professor Atkinson mentioned, is a crime, right? It depends what level of a crime, how many times you've done it, what your history is. There's various levels of criminalization of just the physical crossing of a border without the proper documentation. But what's strange is that the case law and the law of the United States really says that just pure unlawful presence within the United States is not a crime. So there's kind of this big division in the law. And in fact, the Supreme Court and Chief Justice Kennedy have, discussed that, or not Chief Justice, excuse me, Justice Kennedy have discussed that in the Supreme Court opinions. So, there's kind of this big division in how we view immigration law, and I think it relates to bigger divisions in how we view immigrants. There's often a love-hate relationship with many people's view of immigrants. You'll often hear people complain about newly arrived, different groups and how they're not assimilating and how, they're not becoming a part of the fabric of the United States. But then they'll fondly recall their grandparents' immigration process and almost, I find, idealize that to the degree where their grandparents were perfect. And myself as an immigration lawyer and myself as being a little bit critical of this phenomena, I often ask questions and often unearth that there was many times in their grandparents' history some form of immigration fraud. It might not be criminalized to the degree or penalized to the degree that it is today, but many people, it's easy to look back at your grandparents and think that they were perfect, or your parents, and to, villainize new people that are coming over from different places. But many times there were high levels of irregularity and fraud in previous generations, perhaps more than there is today, because detection was not what it is today. So transitioning, I'm going to talk a little bit about the concept of both immigration but also nationality. And when I started teaching immigration law after practicing for almost 10 years and reading a lot of different texts and articles about immigration law, I realized that immigration law is also the law of nationality, okay? And in the United States, we think of nationality as similar to race or ethnicity. But really, it's tied to something that Professor Atkinson discussed, the concept of the nation state, which is the modern nation with borders, right? And there's kind of two different theories of how nationality is transmitted to citizens. So there's one that's jus soli, which is the right of the territory, so it's birthright citizenship, or there's another that's jus sanguinis, and this is, these are not terms that you've probably heard, but that's the right of blood, so that's transmitted more through your parents, right, or your parents' status. And the United States, at least to date, confers citizenship based on birth in the United States, right? But there are groups that want to change that. I don't know if you all know that, but there's been both movement towards initiatives and actual initiatives proposed in various states to try to change birthright citizenship so that children born to people that are what some people might say illegal aliens, I prefer the term undocumented immigrant, would not necessarily be U.S. citizens on birth if certain people had their way just by virtue of having been born on United States soil. Many European countries follow the opposite rule, the blood transmission. So if you're, not literally, but your parents' status can confer you status. And I've represented people that were born in one country and lived in that country till they were teenagers, but were not citizens of that country. And it became very complicated when they came to the United States and tried to get status to try to prove, for example, in a few of my cases that group of people born in France were not French citizens. They were in fact Laos citizens, even though they had never lived in Laos, had never set foot in the country of Laos. So that there's a very different view through the constitutions of different countries based on their legal traditions of how we confer citizenship. And there are people and groups within this country that want to change the way we confer citizenship rights, okay? There's also a lot of history of naturalization being tied to people's race in this country. Really until 1952, all of the naturalization acts written by Congress only allowed white persons, that's how it was defined, to become naturalized as citizens, except there were 2 years around 1870, and I guess later the Supreme Court said that had been a mistake. So they went back to only conferring citizenship to white people until the year 1952. I don't know if you all knew that. And we also have, through the history of immigration, a really strong history of race being intertwined with who was allowed to come, who was excluded, and that type of thing. And I mean, some might argue that that continues really until this day. We had Chinese exclusion in the 1800s. There were different acts, but there was a Chinese Exclusion Act. And, you know, people of Asian origin were often excluded. And there were different laws within the United States also that penalized especially Asian Americans, different alien land laws and things like that, that even when they were allowed into the United States, didn't allow them to fully purchase land and partake in other rights. There were also restrictions on other groups, including groups from Southern, Eastern Europe, and the Mediterranean. And there were various forms of exclusion and quotas that occurred in different time periods as applied to those groups too. And then of course there was this ongoing kind of issue of, in states like California, Arizona, you know, the states that share a border with Mexico, about how in some people's view, you know, the United States could benefit from labor from Mexico, but many times not. The history was that not all people were given the right to proceed to a path to citizenship or to legalization. So the Bracero Program, many of you know about, was a guest worker program, and it caused a lot of problems. There's still disputes that go on to this day between the Braceros and the Mexican government and the Braceros and the US government. And there's some of the older Braceros are now passing away, and many of them still feel that they were not justly compensated by the governments through this program. Over time, so we have a real history of you know, race being very intertwined with immigration law. And we also have, you know, various programs over time, some of which have been more successful than others. But one thing that's sure is that the immigration systems become more and more complex. So during the 1980s, there were these amnesty and legalization programs. And those would allow many people to legalize just because they had been present for a certain amount of time or because they had worked a certain number of days in agriculture. Wasn't too complicated, except that here in this area, as in many areas, there were really high levels of fraud. So many people were excluded from programs that they qualified for because people without a law license submitted sometimes completely fake documents for them, and they were barred from receiving the relief that they were entitled to. That was the time, I think, at least in this area, that immigration fraud became very rampant and out of control, and it's continued to this day. In 1997, Congress passed a package of laws called IRA, and that's the Illegal Immigrant Reform and Immigrant Responsibility Act. And that criminalized conduct, such as just entering and exiting the country. So for example, if, you know, I've been here working, I came into the United States to work and support my family, and been here for years, and then sometime in the late 90s, my grandmother or grandfather passes away in Mexico. And I don't have a visa, I don't have a green card, but I want to go to my grandmother's funeral or my grandfather's funeral. So I just go out of the country and I re-enter. Maybe I'm not even in contact with any immigration authorities. I definitely don't use any fake documentation. Well, the second that I go out and after having been here unlawfully after 1997 and re-enter after my grandmother's funeral, I'm barred for 10 years. There's no way I can get a green card through most family-based petitions. I could marry a U.S. citizen the next day after I enter. I could have 3 kids that are all honor students. I could have a child that's very ill that was born in the United States. But under most of the rules of family-based immigration, I would not be able to then adjust status or get a green card just for having gone to my grandmother's funeral. So a lot of things were penalized very severely post-97 that even were a little bit less strict prior to that. The other thing that IRA did was it very controversial because it retroactively changed the penalty for certain crimes. And some of those were serious crimes, and some of us might argue that that was justified. But there's strange consequences that occur because if you think about retroactive application, in general, as all of the professors here will tell you, U.S. law generally disfavors retroactive application of laws, right? Because kind of in the United States, we support principles of due process and fair notice, and we want people to be on notice of what laws they're supposed to obey and how it might impact them. But there were often strange consequences, so people that immigrated during the amnesty days, like maybe their green card was issued in 1990, would after 1997 go out to, let's say, Mexico, try to come back in and have their card checked, and then be detained and questioned for some maybe incident that occurred where they were accused of a theft crime with some friends when they were, 18 or something like that. And what was strange is many clients that would come and see me would say, well, I told them about this, when I immigrated. And, often that would be, if it wasn't too severe, the Immigration Service would kind of look the other way. But many things became crimes, and technically the government could look back at things that they had basically signed off on and now start to question people or allege them to be deportable for crimes that might have even occurred before they had immigrated. So lots of complicated things happened with the 1997 laws. And there were a lot of class action lawsuits, and some of those things changed, at least for certain people. In terms of major benefits, the last package of major benefits that were afforded to people that entered without the proper documentation expired in April of 2001. And Congress has had opportunities to renew that type of law, which allowed people to pay a fine and have a family-based petition filed before a certain date, so have a valid family member that could file for them and sponsor them. But Congress has consistently declined to extend that particular law, which was called 245I. It's contained at Section 245I of the Immigration Nationality Act. So there's been a variety of other initiatives, since 2001. And I started practicing in 2002. And in those days, we were still hopeful that 245I might be extended again. And then it would be introduced in various committees in various levels of Congress, and it would never go forward. So then, it started to be that different groups of senators and representatives put together different proposals. And in 2006, I don't know how many of you remember, but there was a major comprehensive reform bill that was called the Kennedy-McCain bill. And everyone was sure it was going to go through, and it died. Okay, so, and then, over the years, we now have Deferred Action, which was a program, as Professor Atkinson mentioned, enacted by President Obama. But I'm not sure if everyone realizes this, but the reason that President Obama took action was that Congress multiple times failed to even pass a very narrow law that would benefit undocumented students with very clean records in terms of a green card process. So eventually in 2012, President Obama announced Deferred Action, which is basically just a stay of deportation and a work permit. So Congress hasn't moved forward on a lot, really, since 2001. There's some laws that are pretty protective of crime victims and domestic violence victims. Some are under the Violence Against Women Act, and others, there was a totally new kind of set of laws that are classified also as deferred action that are the U visa and T visa. So those are for the victims of violent crimes and their families, and also the victims of human trafficking. But again, those are very narrow classes of people. So, you know, I think many of you know that during the summer, the Senate passed a bill that's classified as comprehensive immigration reform. Currently, we haven't seen a lot of movement forward from the House. And in fact, when the Senate bill got to the House, there was a lot of talk of a piecemeal approach from many, including many Republicans. And when I hear that, to me that means that certain people are going to put forward totally enforcement bills. So meaning build more fences, put more agents on the border, but not necessarily legalize anyone, or if anyone, not legalize many people that are here. It still remains to be seen. The Senate bill would change things pretty significantly. Traditionally, we've had a very family-based system of immigration. There are certain visas for professional workers and for certain other workers, but really overall, most people in the United States immigrate through close family members. And the Senate bill, if it were to be adopted by the House, which looks almost impossible at this point, would eliminate certain categories of family-based immigration. For example, if you're a U.S. citizen and you have a brother or sister you want to bring into the country, you would no longer be able, after a certain date, to file a petition or immigrate your brother or sister. And for children of U.S. citizens, there would also be certain age limits. We're over 31, if the Senate bill again passed the House in its current form, where you wouldn't be able to file for your children. At the same time, there would be a 10-year path to legalization for certain people that had been here by a certain date in 2011. There's also some temporary worker programs, a specific temporary worker program for agriculture, which would very much affect our area, right, both in terms of industry and the immigrant population. And that temporary worker program, thankfully, unlike the Bracero Program, would allow a path to legalization, although it would take several years. So, you know, the prospects for immigration reform, I'm always hopeful, but I think that if something happens, it's most likely going to be much more limited than what the Senate bill intended to do. And the approach that I've seen is that certain classes of people are being kind of, you know, let in or permitted to attain certain documentation, especially people that we might classify as vulnerable, right? Crime victims are vulnerable, trafficking victims are vulnerable, children who came here at a young age without their consent to entering the country were vulnerable at that time. And it's hard to say what is going to happen to everyone else. And it's a little ironic because among the deferred action applicants, many of them apply not knowing if reporting their information and detailed residence history is going to lead ICE to their parents, either now or someday. The current administration is not interested in people that are the parents of deferred action applicants unless they had you know, prior orders of removal or had criminal convictions. But it's very hard to tell what will happen in the future. So we can hope for something positive. We can push for something positive. But the recent history of immigration law has actually been pretty restrictive and has carved out certain classes of people, but not really passed anything that comprehensively includes the masses since 2001.
So Professor Bobadilla, going back to my fabricated email, right, he says that people should come here legally. So you're a person in Guatemala, and you're sitting there and you're thinking, I want to go work construction in Fresno, California, or I want to do something like that. How could they come legally?
There's very limited options for an unskilled worker, especially, to come to the United States.
So it's very limited. I would say it's virtually impossible.
And often, even if they have an employer, especially an unskilled worker, the wait time and the process currently is so burdensome that usually when an immigration lawyer explains to the employer the actual process and the different things that could occur, most employers just say, forget it, I'm going to find someone here.
So imagine, I mean, you see a border, right? The border says, don't come in. You can't come in. But right across the border, you have these huge signs that says, come in, we have work for you. What are you going to do? You're going to go work. And guess what? Is it the employers? Are they the ones that are to blame? I think we're all to blame because we're all complicit in it. We all like cheap food, right? I think we're all to blame. So I think, you know, that's a problem for me. And another thing that I wanted to point out is that this idea of an illegal entry being a criminal forever, okay? In some jurisdictions, I think in Chicago, if you drive 25 miles an hour over the speed limit, you're committing a misdemeanor, okay? Now, if you're caught committing a misdemeanor, is that the only time you're going to be considered a criminal? If
Yes.
you're even caught, okay.
There's no general class of being a criminal.
No general
Yeah.
class of being a criminal, right? So just because you've done that, are you always in perpetuity living as a criminal? So why is it in immigration, when someone crosses that border, they're in perpetuity living as a criminal? I think it's unfair. I don't know why the remedy has to be that they leave. Why can't it be something else, like any other criminal misdemeanor, paying a fine or something like that? Why is it that we think that they have to leave to atone for the sin? A sin, it's almost like the original sin. The only way you can atone is if, I mean, it carries with you always. So I don't think it's very fair. Immigration reform, right? We're all complicit, so we all should support it. Sorry, those are my political, so I'll sit down now, sorry.
There's a lot of different things you can do. You can come and volunteer with me at the New American Legal Clinic. That's one thing you can do. You can also get politically involved if you're interested in, on either side of the dialogue. You know, there's people that are not necessarily interested in you know, kind of everyone maybe being allowed to come here, or they think that there should be some strict criminal limits. I mean, this is a dialogue that has to happen nationally, and you know, never do, usually when something truly comprehensive is achieved, neither do groups on either extreme get their way. But it's that back and forth, and all the people in the middle, you know, which many of us probably are, trying to contribute to that dialogue and trying to come up with a solution that's good for all of us, all of our children, for those of us that have children, and for the future of our country.